So, hello, everyone. It's a pleasure to have you here for our roundtable from social theory to empirical legal research, rethinking Luhmann and systems theory. I am Lucas Amato from the University of São Paulo. Today, we will have with us Bettina Lange from the University of Oxford, John Paterson from the University of Aberdeen, Mark Hanna from Queen's University Belfast, Edvaldo Moita from Bielefeld University, and Konstantin Skoblik, who is an Oxford Russia Fellow. We have here scholars specialized in social systems theory and that have been working in the difficult process of translating a very abstract and complex theory of society into specific settings and questions that can be empirically researched in many legal fields and legal orders. And then these findings of these empirical studies can work to revise and refine the theoretical apparatus that Niklas Luhmann built up. So my role here is to provide a general context for this roundtable, which will work as a panel of examples and reflections of empirical research under the systemic theoretical apparatus. The idea is to prove that such a complex social theory can be useful to observe practical legal phenomena, institutions, and topics. And in fact, the proposal of this roundtable came out from a series of seminars and publications that I have organized at the University of São Paulo with my colleagues Celso Campilongo, Marco Loschiavo, and Gabriel Fonseca. And we came to edit 2 volumes about this topic. The first one is World Society's Law. It's an open access ebook. I will send you the link to access this ebook. And the second volume came by Routledge this year, and is about Luhmann and Socio-Legal Research. Professor Gunther Teubner is one of the contributors and said that this book makes a gap of research disappear, this gap between the abstract social theory and empirical legal research. So we have then collected many pieces of research from criminology to environmental regulation, from protests and social movements to courts and argumentation, from constitutional rights to public administration, from economic institutions to political history, a lot of topics that have been analyzed using the systemic theoretical apparatus. And observing all these researches, I would say that we have some key points that are critical in trying to put systems theory to work within a more concrete empirical setting. For instance, how does functional differentiation among law, politics, economy, science is empirically combined with other forms of differentiation or restricted by other forms of differentiation, such as gender or race segmentations, core periphery dependencies in world society, class conflict that still works within our societies and within the functional systems. So a kind of challenge is to come out from the purity of the theory to the empirical syncretisms that are synchronous at our world society and its regions today. We have not just the stages, these forms of differentiation, functional differentiation, as a stage in an universal evolution of society, but we have all these forms working together under the primus of functional differentiation, but all these other cleavages still works in our societies today. Another kind of question that we could empirically research is about how are the social forms of differentiation pressed by the evolution of dissemination media, from orality to writing, from writing to press, And today we have this challenge of the increasing digitalization of communication, which emerges within our functionally differentiated society, but generate risks and dangers for functional differentiation. For instance, we have been in our research about fake news. Fake news puts a pressure in the differentiation between the media system, the political system, the healthcare system, and is a phenomenon within our world society, but that presses its forms of differentiation. Another kind of question is how to identify a structural coupling between or among systems, like the Constitution as a coupling between the political and the legal system, property and contract as couplings between economy and law, or taxes and public policies as a kind of institutional interface among law, economy, and politics. How to identify a structural coupling and differentiate it from corruption, from the differentiation, from the colonization of a system to another system. And this leads us to focus on the dimension of the institutionalization of the systems, of the differentiation between legal procedures, economic procedures, political procedures, etc. Another kind of question that many of these papers have been approaching is how to connect these three levels, these three types of systems. The systems of interactions, face-to-face interaction, the systems of decision-making that are organizations, and the level of the functional systems. For instance, we can try to answer and to map the internal structures of each functional systems, which are their core organizations, their peripheral organizations, their public spheres or internal environments, and try to see what is inside each functional system. This kind of exercise can serve us to map the legal dynamics and strategies of legal regulation, the relation between courts that are at the core of the legal system and the legislative or private regulation, which is at the periphery of the legal system. And also we can use this kind of institutional map to think about institutional alternatives, different forms of property, of constitutions, of structural couplings, and of organizations and procedures within each functional system. And a kind of last question that many studies have been approaching is how to work out the functional method proposed by systems theory to analyze case law, to analyze protest and other legal communications. And then we need to pay attention to functional equivalent solutions, to equifinal trajectories, to complex causalities, to the self-reference of communication. We have a lot of abstract concepts from the theory that we need to work out in order to produce more empirically informed research. And in fact, all these are very tricky challenges, and we expect you to find some light and direction about them by being with us today in this panel. I'd like to invite our audience to take part, especially through commentaries and questions in the chat. We will try to answer them during this session, but since we have short time, in any case, you can continue this discussion afterwards, reading our texts and being in contact with us, with all the authors in this panel. And without further delay, I would like to invite Professor Bettina Lange to proceed to her reflections. Thank you, Bettina, and the floor is yours.
Thank you, Lucas, and thanks for this introduction. And thanks for organizing the roundtable. I think it's a great opportunity to think together through issues on how we can harness the abstract theory of Niklas Luhmann for empirical research. So what I want to do today is to base my presentation on the chapter that I contributed to the edited collection that Lucas already as well referred to. So I'm going to share as well some slides with you for that. So the particular theme that I want to focus is on how we can harness Luhmann's systems theoretical ideas for empirical regulation research. And I think there are in particular two challenges that are faced by regulation researchers interested in using Niklas Luhmann's ideas for empirical research. And so the first one is really how to conceptualize the notion of interests. It's clear that Niklas Luhmann doesn't work with a traditional conception of human actors. And so his work doesn't really explicitly recognize interests, but human actors' expression of interests and the struggle over what should be accepted as legitimate public or private interests are really central to regulation. And I think the second challenge that is facing regulation researchers who are interested in using Niklas Luhmann's work for doing empirical research is for those who are particularly interested in the field of environmental regulation, of how the natural environment to each of the social subsystems can be integrated more explicitly into Luhmann's systems theoretical thinking. So, of course, we have already important contributions to the literature that have addressed the point about how we can harness Luhmann's ideas for empirical research. And I want to refer here to the empirical mapping tool that John Paterson and Gunther Teubner developed in order to have a handle on how to collect empirical data as well in particular areas of regulation and carry out empirical research. And so that research contrasted very clearly, captured, for example, here in the diagram that they produced, the standard implementation model of law, that we may want to think of as well, perhaps as the traditional command and control interventionist form of state regulation that says, well, traditionally we start off with a political definition of a problem and the objectives to be achieved by a regulatory regime. We then get a development of a legislative program, and we then go on to the phase of implementation of that program. And at the end, we're going to have desired social effects that ideally relate back on the ground with a result that implemented what was initially the political objective of the regulatory regime. And so the radical departure of a Luhmannian way as well empirically at looking at regulation is then to say, well, we're actually dealing with autopoiesis. We're starting off with a social subsystem of politics, a social subsystem of law, a social subsystem of regulatory activity. And at the end, there are sort of two concentric rings that their interface. We can see as well how through various forms, for example, of structural coupling, operational chains, we may get a regulatory effect. But that is attenuated, and it's one that is happening heterarchically rather than hierarchically. Which is, so we've got that empirical mapping tool. And the first point that I want to make is that we can flesh out that empirical mapping tool, this reference to a key approach in qualitative empirical research. And that is what's called grounded theory. And it's an approach that has been developed, for example, by Corbin and Strauss. It's mainly relying on qualitative empirical data, sometimes also quantitative data. And it's an approach that engages very closely with the empirical data in coding those, then building up a constant comparison of main features of concepts that can be developed on the basis of the empirical data, and that then moves from concepts to creating more abstractly categories, and from the categories and relating them to each other builds up grounded medium level theory. And so we have a way here of building medium level theory that is really grounded into empirical data. And my claim is that this very established approach to empirical social science research really chimes nicely with some key Luhmannian ideas, that they can be brought into dialogue with each other, and so that this approach helps to further flesh out the empirical mapping tool. And so in the Luhmannian approach, we get second-order observations of primary social practices being recognized. And so that chimes in a grounded theory approach with second-order observations of primary social practices, including observations of social actors in a particular field. And so in a Luhmannian approach, we get also social subsystems being considered as recursive and self-referential operations. And so there's a recognition, there's not just one version of the social world, but instead there's a range of communications integrated by different social subsystems. So these can be communications about the subsystem's own operations. It can be communications about those of other social subsystems, and hence it can be communications about the system-environment relationship. And the techniques of a grounded theory approach, I think, chime with that and are equipped to capture these forms of communication, because what we get with grounded theory, qualitative empirical work is a frequent revisiting of data, a revision of research themes, and hence an iteration of analysis in conducting the empirical research. And we also get a form of sampling that is called theoretical sampling. So it's different from the representative statistical sample, and hence theoretical sampling focuses on data that are relevant for fleshing out the dimension of specific concepts. And so in the Luhmannian approach, we get identifying the nucleus of a social subsystem, for example, through binary coding of legal and illegal, which as well helps then to establish the boundaries around a social subsystem, so that all communications with reference to the binary code of legal and illegal constitute the legal system. And again, I think that can be related to and chimes with key ideas of the grounded theory approach, in the sense that grounded theory works with the notion of identifying a core category from which can be built up and around which can be organized the grounded theory that is being developed in the particular empirical context. And of course, on the next slide as well, we can see differences between the empirical mapping tool for applying Luhmannian ideas and a grounded theory approach. So in a Luhmannian approach, we see, for example, the notion that observation constitutes the observer. And traditionally, in qualitative empirical research, we start with the idea that really the observer generates the observation and, for example, records it, say, in anthropological field journals. And so in a communicative process, we see as well within social subsystems that these matter, the communicative processes, in terms of the functions they play for maintaining the operation of entire social subsystems. And I think the opportunity and contribution here of a grounded theory approach is not to take this a priori, just as an uncritical, unquestioned assumption, but to add something else really and go in a slightly different direction by inquiring really empirically in seeing, well, what are the functions that a particular social subsystem is stabilizing, and rather than deducing them from the abstract understanding of a particular social subsystem and an assumed binary code. So I'd like to illustrate that a bit further kind of through the next slide. Thank you. Which comes back to what I mentioned at the beginning, these two challenges that I think regulation researchers in particular face when wanting to use Niklas Luhmann's ideas for empirical research. And the second of those challenges asks the question, well, how can the natural environment of each social subsystem be explicitly integrated into Luhmann's analysis? And so when we start off, for example, with the idea that there's legal and illegal coding, there's commutative processes that constitute the legal subsystem as a distinct social subsystem, I think we can see as well some of the limitations of that. And that is that in the context of eco-socio-legality, that matters in the context of environmental regulation, we may consider this as too blunt and restrictive as a way of coding. So I think the contribution here as well can come from empirical research and further nuancing and developing new forms and seeing and understanding and capturing new forms of binary coding. And these forms of binary coding take into account that we see communication of social subsystems and, for example, the legal system, as well with reference to their natural environment, and for that becoming connected to their communications. And so I want to illustrate that through an example from the context of managing water resources. So we could think there about a binary coding that is about ecological flow and water scarcity, with ecological flow referring to rivers carrying sufficient water of adequate quality to support a range of flora and fauna, with water scarcity being rivers carrying insufficient water of adequate quality to support a range of flora and fauna. And we can see that that binary coding that looks what's actually going on in the natural environment does not map one-to-one onto the legal-illegal binary distinction, because ecological flows may map onto and may be equated to a legal standard for water quality, such as, for example, in the EU Water Framework Directive, but it may not. The legal instrument, for example, the legislation may set a water quality objective that has strong conservation purposes and therefore goes further than what an actual existing ecological flow is, that is supporting what might be a very impoverished notion of the water-based ecosystem, and hence just a very limited range of flora and fauna. So on the next slide, we can simply then just graphically recognize that we may want to add the natural system as one of the concentric rings to the empirical mapping tool that we looked at before, in order to capture communications of distinct social subsystems about the natural environment. And on the next slide, I want to further flesh out really what that means, kind of to integrate and reference as well natural subsystems. So social and psychic subsystems as well as natural subsystems are considered as autopoietic, so that they produce and reproduce themselves. But the difference is that while social and psychic subsystems operate with reference to meaning, natural subsystems, for example, a biological system, may operate with reference to exchange of energy. And we can think here, for example, about exchange of energy between crops and human food consumption. And we may think of further examples of natural subsystems that have distinct forms of binary coding. So in the context of a natural subsystem of animal populations, we may think that there's a food, non-food form of binary coding. So what we get then is that system theoretical mapping can be a very helpful tool for capturing how each social subsystem communicates in very distinct ways about environmental risk, and then poses as well limits to uniformed or shared notions of environmental risk. We may want to ask, so what? A lot of other theoretical approaches can give us the idea that environmental risks are constructed quite distinctly from different perspectives. So on the next slide, I want to set out as well further the implications of, on the first one before that, there's one before, thank you. So the first implication, I think, that arises from the idea that systems theory enables to see environmental risks distinctly, is that we can think about regulatory strategy then that is about harnessing blind spots. So we know from a systems theoretical approach that various social subsystems, and mapping these, we can see as well and identify the blindness that a distinct social subsystem may have to the operations of other social subsystems. Through the processes of communication, it can't fully understand and see and read what's going on in another social subsystem. And we may think that this can be actually something positive to be harnessed for regulatory strategy. So maintaining blind spots can actually stabilize the operations of existing social subsystems, and thus keep their internal complexity manageable, so fully aligning this Luhmannian thinking. And we know that very often this is captured in reference to the legal system through the notion there's cognitive openness, but normative closure. So stabilizing the self-referential operations of existing social subsystems then strengthens the resilience of each social subsystem to exogenous, including environmental shocks. And I think what's interesting that emerges from that is a distinct relational Luhmannian understanding of resilience. Resilience is becoming an increasingly important concept in environmental management. It's part of statutory language these days as well, for example, in relation to water resource management in England. But resilience more broadly as well, what we can see then means from a Luhmannian context is the result of complexity that one social or natural subsystem can provide for another to develop its own internal operating patterns. So here there is a valuing of the internal blind spots, and that helps to qualify as well a notion of integrated environmental management. Integrated environmental management is favored by public policymakers. We can see it as well referred to in, for example, Article 11 of the Treaty on the Functioning of the Environmental Union, where distinct policies are not meant to be public policy, not to be siloed off, but environmental protection measures are meant to be part and parcel of a number of different policies. So that driver in public policy towards integrated environmental management can be critically questioned from a Luhmannian perspective that values maintaining blind spots as well in order to maintain the stability of the internal organization of distinct social subsystems. So the second implication that I think comes from a Luhmannian perspective in the context of environmental regulation is to speed up environmental law during the Anthropocene. So in debates around the Anthropocene, a criticism has been to say that environmental law is really quite slow as a way of dealing with the challenges posed by a changing climate. One of its limitations is the sheer slowness of environmental law. And I think Luhmannian analysis here is helpful for tackling that and for helping to think about regulatory strategy in terms of speeding up environmental law, and that we know from Luhmann that social structures arise from expectations of specific subsequent communications generated by social subsystems. So social structures are not necessarily enduring, but of limited temporal stability. So social subsystems, including traditional legal concepts, are challenged by the occurrence of new natural hazards, but they may also have significant capacity for adaptation. And that capacity for adaptation can be part of speeding up environmental law and hence meeting the challenge of slow environmental law during the Anthropocene. The first challenge that I mentioned at the beginning that as well I think is posed for regulation researchers when seeking to harness Luhmann's ideas for empirical research is that there's no traditional conception of human actors and their interests. But clearly, interests are central to regulation. So if you just look at a definition of regulation as some form of control over the behavior of individuals and organizations, including business actors, for example, through the setting of standards and objectives, as well as monitoring compliance, we can see that clearly interests become central to what should the standards be, what should the objectives be, and so forth. And we see that further fleshed out in more theoretical considerations as well of what regulation entails. For example, in principal agency conceptions of regulation, debates about how the principal, such as a central government department, may keep control over how the agent, like, for example, environmental regulatory agency, is putting the mandate given to it into practice. We see that, of course, as well in private and public interest theories of regulation, foregrounding interests as central to how regulation works. For example, in public choice theories of regulation as a specific version of private interest theories of regulation, the interests of legislators and regulators becoming quite central as well to what regulation is actually supplied, such as, for example, when politicians supply regulatory legislative regimes that as well maximize their chances of being re-elected, or regulatory agencies promulgate regulation that as well extends their bureaucratic mandates to control. So on the next slide, I'm suggesting that Luhmann's conception of human actors doesn't allow for a very traditional notion of interests, but I think it still enables to consider interests and to research them empirically, because I think Luhmann works with a conception of interests as mediated. So mediated interests are refracted. It means that interests are not taken up by the social subsystem in a direct, linear cause-effect way, in the way they influence social action, but the distinct rationalities of subsystems refract and thereby shape the influence of interests on the social subsystem. So in that sense, interests are recognized in the Luhmannian conception, but only as mediated. So on the next slide, thank you. I want to further, as a final point, flesh out how, in really interesting ways as well, in the secondary literature, this has been tackled in developing the notion of mediate interests arising from organization. So various different forms of organizations can be referred to then there. First of all, organizations means just to recognize this as a distinct organized social system in Luhmannian thinking, working with a binary code of member and non-member, and arising from or promoting structural coupling between different social subsystems. So organizations enable the performance of a social subsystem through reference to other social subsystems, and thereby facilitate communication between different social subsystems. And we can think about an example here, such as university, as a result of structural coupling between the functional subsystem of science and the subsystem of education. So interests become mediated here in the sense that the goal orientation of scientific endeavor may be mediated by pedagogical and economic goal orientations of a subsystem of education. But also the notion of the mediator organization has been developed that can help to illustrate the idea of Luhmannian thinking being able to accommodate a notion of mediated interests. And so mediator organizations are considered to promote temporary exchanges between different social subsystems. So here we can think about a social subsystem becoming dependent upon another for only a limited amount of time through expectations of performance. An example here could be, for example, stock markets, in the sense that stock markets render legible and visible the value of corporations, and thereby address the interests that investors have in knowing about the investability of corporations. But equally, stock markets as a mediator organization as well can address the interests of a political system that wants to know about the value of corporations in order to decide taxation policies and in order to plan macroeconomic policy on the basis of taxation policies that are mindful of what we can see as the value of corporations. And thirdly, there are interesting examples around conceptualizations of organizations from a Luhmannian perspective that further flesh out the notion of mediated interests, with that work focusing on corporate organizations, such as, for example, Gunther Teubner's work. So here the corporation is understood not as traditionally being actually to be understood with reference to the interests of collectives of individual human beings, such as managers, employees, owners of capital, or shareholders. Instead, from a Luhmannian perspective, there's a distinct interest of the corporation itself, since the corporation observes itself as a unity. And the corporate self-interest then becomes mediated by a balancing of its function, performance, and reflection. And there are various different ways then on how public interests can start to act in a mediated way on the function of the corporation, to maintain economic activity, on its performance in terms of contributing as well to societal goals, and reflection on how the corporation sees itself internally, reflecting upon itself. But from a Luhmannian perspective, this is only possible to be done in a mediated way, i.e. procedurally rather than substantively, and procedurally, so having some bearing on the internal codes operating in the corporate organization. So thanks for your attention, and I'll stop here.
Thanks, Professor Bettina, for this very interesting approach to the relation between natural and social subsystems, from commanded control regulation to hierarchical and circular models of regulations, and also for this notion of mediated interests that can be very workful to empirical research, I think. And now, Professor John Paterson, the floor is yours. Thanks.
Thanks very much, Lucas. So let me just share my screen. Right, I hope you can see that okay. Okay, so the presentation I'm going to give is based on a couple of things. One, a paper that's in the book that Lucas mentioned. And secondly, a presentation I gave at a workshop organized by Bettina with her colleagues at Oxford and Berlin. So as you can see from the title slide there, I'm risking everyone's patience by going back into the interminable discussion on Brexit, but with a view to trying to understand what happened, particularly in the sort of paralysis in the parliamentary process following the referendum, and then in particular the controversy that surrounded a couple of court cases that grew out of decisions, political decisions that were taken during that lengthy parliamentary process. And in particular, we faced really what we might describe, I think without much contradiction, as a series of constitutional crises where fairly serious allegations were made against the judges, against the judiciary. They were accused of unwarranted judicial activism that really threatened the integrity of the referendum decision, the integrity of the political process. And that, of course, is a pretty serious situation and one that could be quite destabilizing. So what I wanted to try and do was to see whether looking at these issues from a systems theory perspective could give us a different view and perhaps hopefully a clearer view on what was in play. So let me move forward. Hope my slides are going to work. There we go. So very briefly, as Bettina mentioned to us, of course, and as many of you will know, from the point of view of the kind of work that Luhmann developed, society is composed of autopoietic functional subsystems. And these subsystems are characterized by constitutive binary codes. So as we've seen, law, the binary code is legal, illegal, for science, true and false, and so on and so forth. Now, when we're confronted with challenges, issues, some of these are fairly straightforwardly resolvable by the application of such codes, but others are not. In other words, they seem to engage different functional systems, and therefore we can end up with different decisions depending on which of these binary codes seems to take priority. And in those circumstances, we can really see that politics is required to produce collectively binding decisions. Which of these decisions is ultimately going to be the one that is followed through? And as a consequence of that, we can see that politics obviously must deploy power. And for power to be deployed successfully, the proposition is then that it will require legitimacy. When we look at the work of Luhmann, there's a suggestion sometimes that things are not quite so clear when he's discussing the binary coding of politics. But some useful work has been done by Chris Thornhill and Michael King to clarify what we can find in this regard within Luhmann's work. And their suggestion then is that politics, uniquely among the functional systems identified, has a dual coding. First of all, we've got a binary code of government and governed. And then that first part of the first binary code, government, can be further coded government and opposition. Now, for Luhmann, legitimacy is not about some sort of ideal type of government, and that, of course, has led to a criticism of him because he hasn't, obviously nailed his colors to the democratic mast. But of course, he's interested in a different thing. He's not coming forward with an ideal type. He's trying, of course, to explain politics wherever and in whatever form it takes. So his view then is that legitimacy is more a pragmatic matter of what is acceptable, what is accepted. And therefore, legitimacy in action is contingent and dynamic. So acceptance depends on politics both restricting itself to issues which are properly its preserve and not being beholden to another subsystem. So with those sort of conceptual remarks behind us, let's then take a look at the context within which these controversial judicial decisions were made. So, of course, the referendum had its origins in the political program of the conservative-led coalition back in 2013, when the then Prime Minister, because we seem to have got through quite a few Prime Ministers in recent years, but at the time, David Cameron, characterised the UK's problem with the EU as one of democratic legitimacy. So we're right immediately into this issue of legitimacy. And therefore, it was about the location of sovereignty and about the ability to deploy power. So there's no question that what we're dealing with, if we see this as a problem, there's no question that it is a political problem. But crucially, in systems terms, it's more about how politics operates than about the provision of a collectively binding decision in a case which resists resolution by another functional subsystem, which of course is what we were led to expect earlier on. So it was very clear that in dealing with this problem, we were going to have to be very cautious. But of course, caution then was something that was not much in evidence in the following years. Because as expressed by Cameron, he says, it's time for the British people to have their say. It is time to settle this European question in British politics. I say to the British people, this will be your decision. Now, immediately then, you can see that some fairly interesting questions are in play. So, the statute, the piece of legislation that kicked this all off, the European Union Referendum Act 2015, provided the question for the referendum as follows: should the United Kingdom remain a member of the European Union or leave the European Union? So a disarmingly simple question. The difficulty is, of course, that the Act is silent on what should happen in the event that the result of the referendum is that the UK should leave the EU. There is nothing there. The government itself was called upon by the Act to give an assessment of what it felt the decision should be, and the government, notwithstanding that it had set the referendum up, gave its assessment as that the UK ought to remain within the EU. Now, clearly, in a situation where we have parliamentary sovereignty, parliamentary supremacy, and indeed a situation where part of the argument for the referendum was a desire to clarify and vindicate that parliamentary sovereignty, it's interesting what then happened, because in those circumstances a referendum must be advisory, there's no question of that, but the Prime Minister at the time reiterated that the decision was for the people. This will be a once-in-a-generation moment to shape the future of our country. Whatever the British people decide, I will make it work to the best of my abilities. So issues of parliamentary sovereignty were evident, and you could argue that a lack of clarity about what parliamentary sovereignty actually meant and what that entailed in terms of a referendum had been fudged. So, of course, the referendum decided in favour of leave, and the next Prime Minister, Prime Minister Theresa May, was clear that the triggering of Article 50, so the action under the Treaty of the European Union, would be a matter for the government, not for Parliament, because the referendum had essentially afforded a mandate to the government to take that decision. Now, that struck some people as a little bit odd in the context of parliamentary supremacy, in the context of the impact of changing a treaty. In any event, that led to a challenge in the courts. So the courts then were asked to decide who could trigger Article 50. And they were clear that they could only know the will of the people insofar as it's expressed in an Act of Parliament. That was their reading of British constitutional law. Equally, they were clear that the prerogative powers could not be used to change domestic law, which would be the effect, of course, of leaving the European Union. Furthermore, in the absence of clear language to the contrary in the Referendum Act, the referendum could only be advisory. And the courts acknowledged the political significance of the sorts of statements that the previous Prime Minister had made, whatever the legal position, but reminded everyone that such statements were made on the behalf of the government and not of Parliament. Now, that was fairly straightforward, fairly clear. I'm not really aware of many lawyers who found this to be a surprising decision. It didn't seem at all out of the ordinary, but it apparently took the government by surprise, and they were by no means happy with the situation, although of course they had to comply. And of course we had allegations of unwarranted judicial activism. One could argue that in fact this was simply the judges reminding everyone of what the law actually required. In any event, of course, as we know, there was an extraordinary period of parliamentary paralysis, and a really unprecedented crisis situation. I'll just give you one example. I mean, one could go on for hours talking about the extraordinary back and forward and up and down, but 1st of April 2019, a purely coincidental date, there we have a couple of motions being voted on which essentially point in opposite directions. So decisions motions are passed, which essentially indicate contrary things. And what that really exemplifies is that Brexit was not a party political issue. This wasn't an issue then that could easily be thematized according to the government opposition binary code. It was something that transcended those normal party affiliations. As time went on, we had another Prime Minister, and in the context of the ongoing paralysis and his efforts to try and break the deadlock, the suggestion was that Parliament would be prorogued for really an exceptionally long period of time. There were strong suggestions that the objective of proroguing Parliament for the length of time that was proposed was essentially to minimize opportunities to argue against the Brexit decision. So this led to a further challenge in the courts, this time ending up with a full bench of the Supreme Court for the first time. And very strikingly, it ended up in a unanimous decision being handed down by that full bench. And among the really very striking dicta from the court, we have the following: a decision to prorogue Parliament or to advise the monarch to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing without reasonable justification the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive. In such a situation, the court will intervene if the effect is sufficiently serious to justify such an exceptional course. So there's no question that the court was unaware that what it was doing was at the kind of extreme end of its powers, but equally it was very clear in setting out that the criteria required to justify such an intervention had been met. Again, this was strongly objected to by the government. Again, there were some fairly lurid headlines thrown around. But again, could one argue that this was unwarranted judicial activism, or was this simply the court reminding everyone of what constitutional law actually required? So, in systems terms, we could really argue that what has happened is that the way that the referendum was handled really transformed the governed into the government. Because notwithstanding that the focus was supposed to be on the sort of return of parliamentary sovereignty to its appropriate location, the way that the referendum was expressed politically turned the government into the governed. They would be beholden to whatever it was that the people decided, but without any clarity in the legislation as to what would happen in the event that that was the decision. So one could argue fairly strongly, I think, that there was a political misrepresentation of the law which created the conditions for a crisis in legitimacy. So the people had been promised one thing, and when we had these challenges, the courts were compelled by law to tell them that something different would happen. Now, this was to many completely expected. It was simply a return to what the law actually requires. But in those circumstances then, as Parliament sought to reassert itself, you could argue that the actions of those prime ministers could be seen as a further inversion of the binary code. They were the government, but they behaved as the governed, that there was no way that Parliament could intervene, that simply the mandate of the people was determinative in a way that was really at odds with constitutional law. Now, paradoxically, you could say that the efforts of Parliament to re-establish the normal ordering of the binary code, to remind the government about that normal ordering, actually undermined the legitimacy of politics precisely because of the earlier political misrepresentation of the character of the referendum. Parliament, of course, was not unanimous, but that merely confirmed that this was a problem that required careful handling, because it wasn't, as we said before, a problem that could be thematized along the normal government opposition lines. So the crisis, it seems, was avoidable, but in order to avoid the crisis, there needed to be accurate and precise understanding of the UK Constitution. You could say accurate and precise understanding of the distinction between the legal and the political. Now, it really seems in the light of this analysis that that required accuracy and precision only came from the courts. Not, I would argue, in an activist role, but very much in a conservative with a small c role, really essentially reminding everyone of where those boundaries actually are located, the boundaries between law and politics. Let me finish with a quote from Luhmann. "The politicization of power centralizes the decision of conflicts, and it thereby makes conflict with those who decide conflicts hopeless, save by recourse to law." So we could say that in systems terms, law's function is to stabilize normative expectations. The political misrepresentation of the legal status of the referendum raised expectations which the courts were then perceived to disappoint. Law's standing was thus also weakened in the eyes of many. So being clear about what is judicial activism and judicial conservatism is really vitally important for the functioning of the Constitution. Thanks very much.
Thank you, Professor Paterson, for this very interesting reading about how to approach legitimacy, as Luhmann says, the contingency formula for the political system, and how to conceive the function of politics in dealing with these conflicts. Now we will have Professor Mark Hanna. Professor Hanna, the floor is yours.
Thanks, Lucas, and thanks for inviting me, and thanks to the other colleagues on the panel and for the interesting presentations so far. I have a fly buzzing around here, which is causing a bit of interference, but hopefully you won't pick that up too much. So I would just like to begin with a slight disclaimer, and I noticed that the talk and the theme of the panel was billed as to mobilize Luhmann's highly abstract systems theory for empirical legal research. And for my own part anyway, I think it's a difficult task, and I find it a very difficult task to close that gap, what was called a gap earlier, I think when you read out the piece from Teubner. And I think it's worth at the beginning just to note that for Luhmann's theory was really, as he positioned it, was a flight above the clouds. And I think empirical research is more groundwork. And I do think that it's not to say that those are mutually exclusive and incommensurable. I do think that they can be joined together, but I think that the difficulty is covering the distance from the flight to the clouds to the groundwork and then back again to the application of the theory. Generally speaking, as you all probably know, it's not, I mean, even though there has been some literature in the past about the empirical application of Luhmann's theory, generally speaking, it's not an obvious theme of research there. And I even think that there's some hostility to it in certain quarters of those who pick up Luhmann's systems theory. And to an extent, that's because Luhmann's theory is really about radical constructivism, a constructivist epistemology, and blind spots, and self-reference and paradox. And Luhmann himself even was at times a little bit disparaging about the possibility of certainly describing an objective truth, but also even empirical research in the social sciences. And as he said it, you know, science is also a system, and it also has its own values, and it also has its institutional arrangements, and it also has individual careers, and it also depends on society. And therefore, that also needs to be taken into account. And in an ironic way, I think that talks about his own methodological rigor. But then beyond that, and what's really interesting is that when you look at it in some depth, and when you look at it from this angle and test it, you know, there is some basis there for finding some empirical application to Luhmann's theory that he even talks about himself. And specifically, that's really when he talks about his functional method. So in his book, 1984, the Social Systems book, which is really seen as being one of his main books, he talks there for a brief few pages, but it's in some depth at least about what he calls his functional method, which is a little bit complex, but just to simplify it, is really about constructing a problem and using that problem to trace it to equivalent solutions in society, and using those solutions to compare to each other and generating insights on that basis. And I think that he utilized that to a great extent. And it's there in talking about that he really talks about the application of his systems theory for more empirical research. And I'll just quote what he says. I mean, because, for example, you can take, you know, a basic example would be a basic example of a problem would be the improbability of communication, and then you can think about solutions to that. Well, how does television compare to theatre, for example, in solving that? And that's a really basic example, and his problems are a lot more detailed. But as a quote about that he states about how you would deal with something like that, he says in the book, then one comes to statements like, you know, if it really is the case that, for example, television does a better job than theatre in communication, then he goes on to say, then only on the underpinnings of a scaffolding composed of such statements does it seem worthwhile to investigate underlying causalities empirically. And there in that, I think in that passage is the key place that I've found where he imagines the empirical application of his theory. And he's not making a claim to an objective truth, because a page or so later he talks about, you know, he's not saying that this is an objective truth, but rather it's a grasp on reality, as he says, by using the insights of the theory to check something out. And to investigate on an empirical basis the solutions that have been brought into view by the theory. And so that's, I think, where he sees as the empirical application of his own theory. And it's a circular relationship then, as he imagines it, and as I've found it to be also, between the theory and the method, or the theory and the actual empirical research, meaning that the groundwork of actually going and investigating causalities empirically is plowed back into developing the theory. And likewise, the theory and the insights generated by the theory are used to guide the empirical research and to tell the researcher what to look for and how to interpret the data that they are able to uncover. And I think that speaks to an interesting topic that I think Bettina touched on in terms of grounded theory, and the question about grounded theory. And I thought it was very interesting in the similarities you were talking about with Luhmann's theory and grounded theory. And I've thought about that also. And I think I don't know that much about grounded theory, but the only difficulty I see with the application in terms of a grounded theory approach is that grounded theory, as I understand it, starts from a more empirical position, and it's based on empirical observation. Indeed, I think you said that in your presentation. whereas I think the empirical application of Luhmann's is more guided by the theory firsthand, and it's through the theory and the construction of the problem and the bringing into view the various solutions that's what guides the researcher. That's what selects the data they look at in their methodology and things like that. But it's a bit of a chicken and egg situation. So I think that there is an interesting dialogue there, definitely, with a more grounded theory approach and Luhmann's systems theory as well. So that, in a nutshell, is how I see, or the scope anyway, and the avenue I see for a really cogent empirical application of Luhmann's systems theory. I'll talk briefly about my own approach to that and where I've focused that on, and an attempt to mobilize his systems theory for more practical kind of empirical research. I focused on law and the functional application of law, and really what the problem that law was addressing, what solution law was offering. And it was based a lot on Luhmann's earlier more functionalist approach to law, and especially his writings in the early 1970s about the sociological theory of law that he came up with there, before all of this autopoiesis stuff and everything like that, where he basically said that, the problem that law is answering in society is stabilization of normative expectations, and that law does that job better than any other system, or at least it used to, and perhaps it was doing that in the 1970s better than any other system. And I focused a lot on, in particular, on the problem of normative expectations. Now, normative expectations are expectations that people do not give up in the face of a disappointing reality. So even if they face persecution or punishment for expecting that, they still hang on to it. It's a classic kind of protest expectation. It's differentiated from cognitive expectations. Cognitive expectations are expectations that we learn to give up in the face of disappointing reality. So I may expect that it's going to be a sunny day, but when it turns out that it's raining, I don't hang on to that expectation. It's a cognitive expectation. I adapt to it. And it's a binary distinction there, and I'll not really go into great depth on that. I think, Bettina, you also talked about that as well, and the importance of binary distinctions and observations of observations. And I think that fits into the mix here as well, and makes normative expectations a kind of good concept for empirical application. But what's really important about normative expectations is they register social facts. They are not purely psychic in that sense, and they will actually register in the social structure because it's always a protest. It's voiced. If somebody hangs on to an expectation, it will register in some way in the social structure as a protest against the disappointing reality. Not all of those normative expectations will be selected by law. Not all will be important, but some will be. And you can focus on those in that respect. And so therefore, normative expectations, I think, offers a program for observation. And I considered normative expectations in the chapter in relation to what Herbert Blumard said about social theory and the problems of social theory in terms of empirical research, and saying that social theory was too vague, certainly in the 1950s, and maybe he had Parsons and people like that in mind. And he said what social theory needs is more definite and sensitizing concepts. So these must be definite concepts, and that they're starting with definite concepts in their empirical research. They know what they're looking for, and it's not conceptually vague and can be conflated with other things. So it's empirical in that sense. And then sensitizing in the sense that it reveals things, and it reveals insights, and is able to break frames in that sense. And I think that that's what normative expectations have. They are definite in the sense that we know what we're talking about when we're talking about normative expectations. It's quite simple. These are expectations that are not relinquished in the face of a disappointing reality. They are that thing, and they are not cognitive expectations. They are not given up or learned to adapt and given up in face of a disappointing reality. And so in that binary structure, then we have a whole universe. You have either normative expectations or cognitive expectations. And in that, you have the definitive nature of normative expectations in that matter and the satisfaction of what Bloomer recommends for empirical research. And then secondly, they're sensitizing because we typically don't look at law through this optic of normative expectations. And indeed, when people talk about systems theory and law, they mostly talk about the binary distinction of legal, illegal. I think as both of you, John and Bettina, have actually mentioned today, that's typically what we talk about because that's what Luhmann actually turned his attention to with Law as a Social System when he turned to autopoiesis in the 1990s. But before that, there was this focus on this different binary distinction between cognitive and normative. And actually in his earlier work, he said that's really where the ought is located. And that's why legal theory and analytical jurisprudence has everything wrong and heart and everybody. This is what they should be focusing on, this distinction between cognitive and normative. So, and I think that when you look at normative distinctions, normative expectations, and you use that as a program for observation and empirical research, it brings to the fore a lot of things that we haven't seen before about the relationship between law and society, and a lot of interesting insights in that respect. I'll talk briefly about my application of it, well, I mean, I've done a few things in the past, but I wanted to talk about something that I wrote more recently on it, although I've not published it, and I'll talk a bit at the end about why I've not published it, because I think that enters into the whole subject of this. But I wanted to talk about the empirical example I looked at of the expectations of Claudette Colvin. If you don't know, Claudette Colvin was a 15-year-old black girl from Alabama, Montgomery, Alabama, and in 1955 she refused to give up her seat to a white person on a bus. This was 9 months before Rosa Parks, and she later became one of the plaintiffs in the Supreme Court case of Browder versus Gale. And Browder versus Gale is a very brief judgment by the Supreme Court after the federal court already given judgment on it, but it's famous in civil rights history because it was the case that effectively outlawed racial discrimination of public transport throughout the United States. You know, why I picked actually Claudette Colvin's case was because there was so much evidence in the case, documentary evidence of her normative expectation from the very first moment where she was on the bus, and there was multiple observers on the bus, and they were all documented in court transcripts and police reports. Of her first no that she actually voiced against when she was asked to move seats, to her arrest, being brought to City Hall, being brought for trial, the appeal case, the loss of the appeal case, and then the whole civil society movement that coalesced around that, and Rosa Parks that came out of it and everything like that, all the way up to the Supreme Court. So what I found was actually that, you know, you can look at one of these situations where somebody voices a normative expectation, and you get plenty of documentary empirical evidence of that expectation being voiced in the social structure and registered in the social structure, and all of the kind of social structural couplings that come out of that. And you can kind of chart that narrative arc on a more empirical level to the final change in the law. And the change in the law there was explicitly connected to Claudette Colvin's expectation. One of the things that was interesting about the case was that the lawyer, Fred Gray, kept having to go back to Claudette Colvin and asking her, did she want to pursue the case? And was she pursuing the case on her own volition? Because one of the things that the white power structure in Montgomery tried to do was to impeach him for soliciting these cases and to disbar him on that basis. So he had to be very careful to actually record at multiple points her normative expectation. So you have this kind of whole story where you have consistently recorded through different types of documentary evidence and videos of interviews after the fact and everything like that, where it's documenting to a great extent, the normative expectation that she has. And you can plot this course between her normative expectation being first voiced, and then the change in the Supreme Court case of Browder versus Gale. Rosa Parks was not a plaintiff in the cases Browder versus Gale. Her case was tied up in the Alabama courts, and they decided it wasn't a good strategic move to try and to get that to the Supreme Court. So actually it was Claudette Colvin and 4 other women plaintiffs who agreed to act as plaintiffs in that case, and who were able to actually voice their expectations to the courts and to affect that change in the end. So I done all that research, and it was a lot of work actually going through all of the different empirical records to record her expectation as it manifested itself along the way. At the end, then there's a question about, okay, well, how do you apply that back into the theory? And that's the part I haven't actually done now, and I think it's really costly, and that's why I preceded the talk by saying it's not easy to make the jump from the flight from the clouds to the ground, do the groundwork, and then back to the flight from the clouds sort of thing. There's a lot of work in it, and I haven't actually, after getting through all that empirical stuff, done the work on translating it back into the theory. But what do I think it brings to the theory, and how does it refine the theory, and how can it be applied back into the theory? I think it teaches us a lot about the structural couplings that do happen with law. I think it teaches us a lot about the functional equivalence to law. What you see in the Montgomery case is all these functional equivalents being brought in terms of organizations, certainly civil society organizations, from the Montgomery Improvement Association, which was headed by Martin Luther King, to other civil society organizations were operating in Montgomery, which were clearly having a very structural role in helping the movement and helping to bring the expectations of people like Claudette Colvin and other people to the courts, and lawyers and professional roles and things like that. But you also, I think one of the biggest things for me was, and to go back to something that Lucas said at the start, was the importance actually of interaction systems as well. And it made me think of systems theory in a way that I hadn't thought of before, just by doing this empirical research, because we tend to think of systems theory as being all about functional systems. But actually, when you look at Luhmann's whole body of work, he's not only talking about functional systems, he's also talking a great deal about organizational theory and organization systems as being another important type of functional social differentiation. And he's also talking about interaction systems, which he doesn't give a great deal of attention to, but it's certainly there in his work. And I think after doing this research on Claudette Colvin and the empirical basis of that normative expectation, what it really showed me was the importance actually of interaction systems in the development of things like law and in the development of these functional systems. And I think that was actually didn't get the attention it deserved in Luhmann's work. And I think when you start to test his theory out on this more empirical basis, it's something that really comes to the fore, that actually this is actually an important element of this too. So I'll just end there and in conclusion say, I know there's lots more to Luhmann's theory than the narrow approach that I've had here of just testing out this thing about normative expectations. I mean, there's certainly more to his work than normative expectations, but just by taking that small area of his theory and trying to test it empirically has been quite fruitful, certainly anyway, in terms of for me, and just what it teaches you about normative expectations. And I think that it's an important empirical agenda, or could be an important empirical agenda for systems theory, and it illuminates much about law that's perhaps been overlooked. And for me, looking at normative expectations on this empirical level taught me and really made me reflect back on Luhmann's theory as being something much more sociological than I ever thought it was. And I mean that in the sense that it's actually about real people. And I know that it's a bit of a thing, not or that might sound unpopular in some Luhmann circles to say that Luhmann's theory is actually about real people, because it's about systems, and Luhmann doesn't care about humans. But actually, when I looked at the situation with Claudette Colvin, I seen that, well, hang on a second here, it's not actually courts who change law, it's not elites, and it's not even completely organizations. What the change and development in law depends on, and indeed what the development of fundamental rights in law depends on normal people who have the courage to actually voice their expectations in the face of persecution and in the face of alienation, and to hang on to those expectations against that. And I think that even just that one thing is a really important insight. And it only came about for me just by trying to actually test out the theory and look for some empirical instances of it. So if that's anything to go by, I think that there's a huge use in trying to have, test out Luhmann's theory and to have an empirical agenda for the theory. But again, with the disclaimer that it's hugely costly to do that in terms of time and resources. It feels like you have to do both the theoretical work and sort everything out in the clouds first of all, and then go looking for all of the empirical instances of it, and then come back and apply it back to the theory, because there has to be this circular relationship between the theory and the empirical research. So hugely costly. Where will it get funded? I don't know, but I definitely think that it's a worthwhile venture anyway. Thank you.
Thank you very much, Mark, for your methodological remarks and for your insights on how to rescue what Luhmann said in the 70s in a sociological theory of law about normative expectations, this very central category that Luhmann marginalized a little bit in his later work. And now we move on to Edvaldo Moita, who has just presented a very acclaimed dissertation at Bielefeld University. Edvaldo, the floor is yours.
Thank you very much, Lucas, and all of you for taking part in this session. I hope you're listening to me. That's all fine? Okay, no? So my intention here is to present my dissertation. I sent you an extract of it, more specific here for us. But I will try to show at least the main subject of the research, which is basically focused on the concept of non-compliance. So I deal with non-compliance on an empirical basis. Then we are going to see how it works with informality. That's my sample. And on the nature of non-compliance as a legal phenomenon and the impacts of pervasive or recurrent non-compliance. And then I deal with Luhmann's systems theory a lot, and also Paterson's in this matter. So I'll try to summarize my findings here. Well, when we are talking about informality, I hope you're seeing the screen. It's okay, no? I chose informality not by chance. It is a striking case and striking example of non-compliance, and it is a global challenge right now. Even the United Nations is trying to overcome informality on a global manner. We can see this on the SDG number 8 from the United Nations. Here, target 8.3 on the mission of creating decent job and encouraging formalization. And that's not out of chance. Informality is a problem worldwide. For us just to have an idea of how pervasive and how big the phenomenon is, or to use Laporta's words, it's huge. That's a graph published in 2018, but with the data from 2016, we had about 6 to 1.2% of the world employed population working in the informal economy. That amounts to 2 billion people. And when we see an inside pretty steady phenomenon, which tends to get worse each year, just during this pandemic, for instance, we have more or less 1.6 billion workers in these conditions of informality, in risk of losing their livelihoods. In Brazil is a pretty representative case of these numbers. That's also a graph for us to have an idea of Brazil. On 2019, we had about 41% of the employed population under the conditions of informality. Of course, these measurements, they change a bit depending on the country, on the data being analyzed. In Brazil, I brought, in order to understand the Brazilian situation, I brought to you a map. Informal workers, they are considered those ones in the white blankets, the white squares here. The most striking number, I think you can see, is it's under the category on account worker, and then we had on 2019 about 19.4 million informal workers. That's where I take my qualitative study in street vending from this number here, because street vendors, they are the most conspicuous case of informal workers. But in any case, when we are dealing with informality, of course, there is a dispute or a debate on the concept itself. And there are many ways of referring to this phenomenon, or at least dimensions of this phenomenon. So there are people talking about unreported economy, parallel economy, unofficial, subterranean, invisible, shadow, illegal economy, and so on and so forth. But what matters is this, regardless the measurements or regardless the definition, all of them, and I'm using here Professor Edgar Feig's summary, all of them deal with economic agents engaged in non-compliant behaviors that they seek to hide. I would not agree with him, at least in this part, that they seek to hide. As we will see, there are lots of non-compliant activities that they are not hidden at all. But in any case, in order to show how non-compliance takes place, empirically speaking, then I do this qualitative study on street vending. Street vendors, they are pretty much seen everywhere around the world. We are talking about people that they sell goods or merchandise, or they offer services on sidewalks, public squares, streets, avenues, near public buildings. And regardless the kind of street vending is involved, what is remarkable is that at least in different layers, we are talking about illegal activities here, or non-compliant activities. For instance, in Fortaleza, we can see this street vendor selling alcoholic beverages. And at that time, the selling of alcoholic beverages was forbidden by law. Nonetheless, we could see street vendors selling this kind of product everywhere. And not only that, in Brazil, for instance, it's also forbidden to have lotteries, except for the government ones. But we have what is perhaps the biggest illegal lottery in the whole world, the animal game lottery. And here we can see a street vendor selling tickets of this lottery, and with the official ones too. And we can see them pretty much everywhere. And there are lots of examples I give on my dissertation. But what I want to make it clear is that if there is a problem already in the activity, when we see it, the vendors as a single unity, it becomes even more problematic when they gather together and they form what is known as open air markets or street markets. Here I'm showing the largest street market of the city of Fortaleza, but it's one of the biggest markets in the whole region, northeast region of Brazil. They are selling clothes and tissues here in the middle of one of the main avenues of the cities, in the city's downtown, in front of the cathedral. Just behind the cathedral, out of curiosity, there is the city hall where the mayor regulates the city. And this activity, these street markets, they are legally speaking all illegal because they are occupying streets and avenues to exercise commercial activities which violate the constitution of the municipality. And that's just one street market. In the city of Fortaleza, we have about 68 street markets like this. This one, Granja Portugal, another neighborhood, you can see that they are occupying the streets and they are violating to another regulation that forbids the occupation of the street to such an extent that pedestrians cannot walk around without obstacles. But in any case, when we observe those activities, we can see different forms of non-compliance. And in the second chapter of the dissertation, I tried to propose a conceptual architecture to grasp each layer of non-compliant behavior. Being the first one, the simplest one, the layer that targets the norm addressees, that is the people whose behavior is being regulated. Then I categorize this kind of non-compliant behavior in terms of obedience and disobedience, but non-compliance is not restricted to norm addressees. We can also see non-compliance being performed by law enforcement agents. And in this sense, I try to show how this happens in terms of failure. That is, when law enforcement agents, they try to apply sanctions, but they fail doing so. Or they can, but they choose not to, so they forbear applying sanctions. Or they chose to do it, but they normally abuse the application of sanctions, normally imposing more harm than they are legally allowed to. But non-compliance also happen in courts. So I analyzed a bunch of legal cases dealing with street vendors and street markets, and we can see inconsistent cases there, in the sense that when it comes to street vendors and street vending, the same cases are being treated differently by the same judge or different judges or appellate courts or superior courts and so on and so forth, to an extent that we cannot really identify what is the reasoning of these cases. Of course, when we are dealing with non-compliance at this level, this is a pretty normal phenomenon that we can see everywhere. And the legal system is able to handle it in different ways and through different means. But the question is, and that's the question I'm most concerned with, is what happens when non-compliance achieve high degrees? And then I try, that's where Luhmann comes to the table. And I've observed that non-compliance in certain cases, it's not only seen as an event of non-compliant behaviors, but it becomes a social structure in itself, in the sense that people expect that legal norms will be disobeyed, that law enforcement agents, they will fail when they try to apply the sanctions, or they will just forbear applying the sanctions, or they will abuse emergent with my, in the sense when even cognitions see that series of cognitive expectations that undermine the normative, the counterfactuality of legal norms, their normativity, so to say. I tried to sample my findings in what I called arenas of non-compliance, and we can see the arenas of non-compliance in different stages. I analyze, specifically speaking, the spatial stage of the arena, where interactions take place. So I also dedicate part of my research to observe the interactions between vendors and law enforcement agents. And it's through interactions that conflict and violence, they appear or they emerge as a consequence of those structures of non-compliance. But there is the most striking consequence of a structure of non-compliance, and that's where my presentation will focus on. And the piece I sent you also tries to depict is the deflation of political power. When we see arenas of non-compliance, there are lots of resources that enable people to act according to their interests. But the one that I analyze with a more caution is exactly the resource of political power. And that's where I resort to Parsons, which is who is really close to Luhmann in this regard. When we talk about political power in Parsons, we are talking about symbolically generalized media of interchange. In Luhmann, he does not accept the interchange, and he proposes symbolic generalized media of communication. That does not change very much what I wanted to say, but the people who possess power in an arena of non-compliance, they are at least entitled to three things. They can speak in the name of the collectivity. They can produce collectively binding decisions. And when they produce collectively binding decisions, then we have the third aspect. They can insist upon the compliance of these decisions. What I want to contend here is that when we observe the empirical case I studied, we see the asymmetry between the collective part of political power and the binding part of the political power. We see the issuance of political symbols, of collective decisions, but without the correspondent basis of fulfillment. That is to say, without the capacity of being binding on the collectivity. When this happens, the consequence is the loss of the symbolic character of political power. And when power loses this symbolic character, we see the emergence of battering practices. That's what I'm borrowing this part from Parsons and then apply it from what a German professor, Professor Goethe, talked about in the 80s, and I try to update it in a certain sense. But there are lots of bothering practice as reaction to pervasive non-compliance. One in particular is the legal agreements that are provided by law. In those legal agreements, in which the parties concerned with certain case, they can bother or negotiate the standards of compliance. The most common one is the one seen in the Public Civil Action Act. I brought to you here the legal text that authorize this kind of agreements. They are called the terms of conduct adjustment. But in any case, the parties become authorized to bother legal norms. In principle, this happens as a means to overcome non-compliance and achieve, on the long term, to achieve full compliance. And we can see, I brought you one. Unfortunately, it is in Portuguese, but I'll try to translate here what is interesting to us. So when this bothering practice happens, we see that the parties, that is on the first clause, they recognize that their behavior is illegal. So this agreement here regards the occupation of the public square surrounding the cathedral, and the mayor was forced to remove the vendors since 2006, but they never made it because the vendors they entered in conflict. We are talking about a mass of vendors, violence that happened between the police and the vendors. But in any case, every attempt to remove the vendors was not successful. So everybody recognized that we are talking about an illegal behavior, not compliant behavior, recognized by the mayor, recognized by the police, recognized by the judge, recognized by the vendors themselves, but they bother the legal standard, which is to not occupy the full standard of compliance, which is not occupy the public space. And they create rules of transition. Okay, in order to achieve this full standard of compliance, we'll create transitory rules, such as we will allow the vendors to occupy the public space after midnight until 7 a.m. during 4 months when the transition should end. The point is, despite these agreements, the full standard of compliance is never achieved. Furthermore, the agreement itself is violated. So the battering practice creates more opportunities to non-compliance, and this deflates political power even more. You create symbols of political power by means of legislation, ordinances, court decisions, or legal agreements between parties. But instead of achieving compliance, you create more opportunity for people to not comply with the law. And this brings about different consequences. And the one I try to show in my work is the flexibilization of law. We pick up legal norms that they have on their nature, they are norms of commands and prohibitions, and we change their nature into offers of regulation, giving the parties the powers to decide what are the standards of compliance. But in each case, they create, in the end, more non-compliance in the sense, fortifying or stabilize the structure of non-compliance. So there is more or less what I want to focus here. I will not take more time, and thank you very much for listening.
Thank you, Edvaldo, for your insights on how to observe the blind spots, the other side of the law, the illegal practices, the non-compliance, and so on. Now I think that we can have some more 15 or 20 minutes to listen to our last presentation by Konstantin Skoblik, who will present his research about system theory and courts. Konstantin, the floor is yours.
Thank you very much. Let me just share my screen. Is it working?
Yes.
So I'm going to start, and our roundtable is devoted to the questions of mobilizing Luhmann's theoretical apparatus in the empirical legal research area. And for me, it's about integrating the systems theory into the methodology of a particular study. And despite challenges originated from high complexity of autopoietic approach, I've tried to do such an integration in the study on the jury reform in Russia. And first of all, a couple of thoughts about this reform. Nowadays, the Russian criminal justice system is experiencing broadening jury trials. The current reform, which began in 2018, expanded jury trials to the level of district courts. Before, they had been operating only at the level of regional courts. Although the reform has only been going on for 2 years, it's already posed some crucial challenges for the Russian criminal justice. The main disturbance to the system is that the acquittal rate from juries at the district level has risen sharply. Thus, the contradictions happened. On the one hand, we have the acquittal spike. On the other hand, the Soviet Russian system aims to keep a low acquittal rate. So it was interesting to explore sociologically how broadening jury trials affects the justice system and what tools this system employs to stabilize itself. If the system is essentially striving to decrease the likelihood of acquittal, what strategies it deploys to get a guilty verdict rendered and consequently control the acquittal spike over the reform? In my view, it would be difficult to answer these questions without resorting to a systems theory perspective. it was important to envision the Russian criminal process as a single actor, not as an assemblage of various actors, such as judges, procurators, defense attorneys, and so on and so forth. I considered the Russian criminal process as a subsystem of law, which uses the code guilty, unguilty. Since the Russian system is trying to achieve the high conviction rate, it also operates on the basis of an intentional program of the crime control. The crime control program was introduced into the criminal process by the political system in the Soviet time. Because of that goal-oriented program, the justice system has significantly decreased its capacity to produce the difference. It primarily operates with the distinction guilty. In turn, the differentiation tendencies emerge. The Russian criminal justice system acquires traits of a predictable, determinable, trivial machine, whose the most frequent output is the conviction of a defendant, not the acquittal. Taking into account these peculiarities of the Russian system, it comes as no surprise that broadening jury trials irritates and destabilizes the system. Trials by jury provide a continuous influx of uncertainty in the form of acquittal risk. The system views the acquittal as a risk, not a danger, because it tries to avoid acquittals and develops the acquittals prevention strategies. The risk concept exactly means that from the system's point of view, it's possible to prevent an undesirable future. Development of the acquittals prevention strategies is based on the system's learning capacity, the capacity to accumulate and disseminate experience by interweaving individual legal episodes, that is, by interweaving different jury trials. During self-learning, the Russian criminal justice mobilizes its memory and intelligence. The memory allows the system to banalize irritations and apply the previously developed strategies of acquittal rate control. The intelligence is responsible for the invention of new tactics, which hadn't existed before the current jury reform came. After I conceptualized the Russian criminal justice through Luhmann's theory, that is, after I redescribed the object through the semantics of this theory, the next step was collecting empirical data. To achieve this task, I observed trials by jury, lawyers' working groups, and conducted some interviews with judges, procurators, and defense attorneys. These methods centered around oral communication patterns. By doing this, I was testing research hypotheses. Firstly, being the structural coupling, the trial by jury irritates the Russian criminal justice system. Secondly, one of the most irritating factors is increased prospects of acquittal verdict in jury trials. Thirdly, having resonance, the system varies, selects, retains different strategies of its stabilization. And some strategies of the stabilization, or how I call them, the strategies of the acquittal verdicts prevention, were also discovered. And now turning to those strategies. The first strategy utilizes the ability of the Russian criminal justice to transform the communication connected with the unguilty side of the code into the communication relevant to the guilty side. This is about how, because of the differentiation, the system deals with the communication within itself. Since the differentiation impedes the reproduction of difference, the justice system becomes obsessed with the guilty side of the court and the communication relevant to that side. I've called the strategy of blocking unwanted communication and providing the preferable option, manipulation in communication. This strategy implies a number of tactics detected in the 5 trials: ruling out the question asked by one of the parties, interruption of the speaker, warnings and reprimand, advising the jury to disregard comments, and the tactics can be used singly or in combination. In the example of singly used tactics, the judge is considering the question asked by the defense as a procedural one and ruling it out. In so doing, the judge is stopping the undesired communication. The following example illustrates a combination of tactics. Here, the judge is also stopping the communication, although he is already using two tactics, the interruption of the speaker and warning. During observations of mine, I also tried to link particular variables, indicators, with the situation of communication change within the system and with de-differentiation. I was counting how often the manipulation in communication happened, how many times judges ruled out the question, interrupted a speaker, and so on. And the figures for the 5 trials are as follows. The strategy was applied 169 times at the following stages. The strategy was addressed to the defense 139 times. And comparatively, on only 30 occasions was a communication manipulation strategy deployed against the prosecution. From all these numbers, I can draw the following statements. The stage of witness examination is the primary source of irritations and reactions of the system. Contrary to that, the lowest number of reactions is detected at the phase where other pieces of evidence are presented to the jury. Such differences are explained by the fact that verbal communication generates more undesirable uncertainty within the system when written. The judge, prosecutor, and attorney had the opportunity to get acquainted with written evidence before the beginning of a trial. This decreases the extent of unexpectedness which arises during the presentation of written evidence. Meanwhile, the chance of immediate witness examination appears only in trial. Before that, parties cannot officially ask witnesses for their testimonies and get information in advance. Thus, in the case of verbal communication in general and in particular witness examination, the trial becomes the arena where everything can happen, and none of observers, including the system itself, can foresee the demeanor and answers of witnesses. And this destabilizes the system, since because of de-differentiation, it's trying to remain predictable and determinable regarding its traditional output in the form of the conviction. The operation on the guilty side of the court can likewise explain the fact that most frequently the strategy of communication manipulation is addressed to the defense, not the accusing party. And there was also one interesting paradox concerning the manipulation in communication strategy. The non-application of any tactic in particular situations may be interpreted as deliberate non-response. This non-response, or more precisely, the reaction of the system through this non-response, can be qualified by the system itself as a procedural infraction and can be a reason for the reflexive unit of a system to overturn the acquittal. Such a situation, then the judge and prosecutor collusively introduce trial errors in order to assure a grounds for the acquittal reversal is not new for the system. Other researchers have already paid attention to this tactic in the jury trials at the level of regional courts. It seems to me that the system's now mobilizing its memory, banalizing irritations, and transmitting tactics devised during the first wave of jury trial resurrection from the regional courts to the district courts. And let me turn now to the second strategy. It's called trial recursion. And this is about the unexpected returning to the evidence examination stage. I can explain the strategy in the following way. Prosecutors, after their evidence is examined, let the defense present its case. While the defense is presenting its evidence, procurators are waiting for the fortunate moment. After the defendant is questioned and evidence of a defense is presented, procurators say they have additional information and present new pieces of evidence that disprove the defense evidence and the defendant's testimony. As one of the judges put it, after the defense evidence was presented, the accusing party would twist all things to their advantage, like a psychological feint meant to impress the audience, the jurors. I can speculate that, contrary to the intentional introduction of trial errors, the trial recursion strategy is the consequence of a system's intelligence. The defense attorneys told me they hadn't witnessed the sudden presenting additional evidence by the prosecution before the jury reform started. The trial recursion strategy is precisely the case when the system invents, selects, and retains new tools of its stabilization. Apart from aforementioned things, the research findings also include the trial acceleration strategy and other instances of a systems learning phenomenon. However, due to a time limit, I won't now develop this aspect, and in turn, I focus on the following final remarks. Employing autopoietic framework wasn't a completely spontaneous or intuitive act. Using Luhmann's theory was based on some sort of technique on the methodology for constructing methodology, so to say. The first step of this methodology is called conceptualization and means imposing the concepts grid on the research object, on the Russian criminal justice case, on the Russian criminal justice in my case. The conceptualization is a redescription of object through the semantics of a particular theory, and the observer decides what theory should be used. If I conceptualize the object with the aid of Luhmann's theory, the criminal justice becomes a system, the jury trial acts as a structural coupling, the variation, selection, retention appear to be the variation, selection, and retention of acquittals prevention strategies. The conceptualization implies the idea of deduction and traits attribution to elements of object. They can reason each autopoietic system is characterized by this, this, and this. The criminal justice is an autopoietic system. Consequently, the criminal justice is also characterized by this, this, and this. But the conceptualization is only the initial deductive stage. The most problematic part comes later and can be called operationalization. And from my standpoint, the Roundtable is exactly about the operationalization. That is about how we can translate concepts of the systems theory into certain variables of socio-legal study, about concrete indicators of the system's resonance, differentiation, and de-differentiation. To do operationalization and detect strategies, I described each of the observed trials as a set of communication patterns with different results. The theoretical framework based on the use of communication pattern made it possible to detect a number of strategies and define their elements, as well as the moments when they start and close. The communication pattern concept is an additional, in my view, is an additional severance of the communication circle. In my opinion, the first severance occurs when they use the concept operation, With the help of that notion, it becomes possible to single out the first operation of communication, the second one, the third one, and so on. It allows us to say that the second one connects with the first one, in turn the third one connects with the second one, and the like. Temporal distinctions, past, present, future, also divide this never-ending communication. Distinction, previous, subsequent communication is the derivative from these temporal distinctions. Against this background, the communication pattern is just another tool of severance of totality communication for the sake of operationalization. When they are equipped with the operation concept, communication pattern, present, past, future distinction, they can count, measure, and use quantitative data. Now, I'll finish my presentation and thank you very much. I do appreciate the opportunity to share my research findings and get feedback from scholars who specialize in Luhmann's theory. And I hope you've gained an insight into the current jury reform in Russia. Thank you.
Thank you very much, Konstantin, for your very original construct about the jury trial as a kind of interface between the criminal system and the political system, and for your insights in translating concepts as variables for empirical research. I think that unfortunately we have run out of time, but I invite you all that are watching us to get in touch with the texts of the panelists, the speakers today. We have published these two books, and I invite Edvaldo and Konstantin to contribute to a third and I think the last volume of this trilogy of studies showing how to work out systems theory in empirical legal research. I invite you all to get in touch with these books, with other papers from the speakers today. And I would like to thank Professor Bettina, Mark, John, Edvaldo, Konstantin, and we keep in touch, sharing experiences, sharing our researches in this kind of network that we are building about this topic. Okay, thank you very much for your attention, for being with us today, and we keep in touch. Thank you.
Thank you.
Thanks very much, Lucas. Thanks, everyone. Bye-bye.
Thanks,
Thank you very much.
Thanks, Lucas. Very good to meet you all. Thank you.
Bye.
Goodbye for now.
Bye-bye. See you. Thank you for our audience that have been with us since this time. See you. See you.